I'm glad that you're a member of our Prison Professors YouTube channel and program. We strive every day to produce new content that will teach and inspire people who are in prison, but we also want to provide free content and resources for people who may be going into the prison system or for family members who have a loved one in prison. And today I am privileged to do an interview with my friend Josh Boyer, who's also a member of our team at both Prison Professors and Compliance Mitigation. Josh, say hello to our audience.
How's it going, guys?
So Josh and I have one thing in common, and that's that we both served a really long time inside the Bureau of Prisons. People who watch our program know that I was incarcerated for 26 years. Josh, why don't you tell the audience a little bit about your journey?
Well, definitely not as long as yours, Michael, but
pretty close.
Definitely, it was. Started out in 2001, early 2001, and man, it kind of stretched onward from there up until 2016 when I got clemency by President Obama.
Oh, so you got clemency. So you were incarcerated for a total then, I thought it was 17 years. Was it 16 years or 15 years?
Close to. I actually had to do after that, the condition of the clemency grant was based on my participation in the RDAP program, which it's a 9-month program. So it took a little while to get me into the program. And then by the time I got a chance to participate, do the 9-month phase, I went to the halfway house immediately thereafter.
So it's great that you've got a tremendous amount of experience, both in terms of RDAP, clemency, serving a lengthy time in prison, and just being a real resource to anybody that comes into our community. You're really knowledgeable about different security levels and everything else. And you've also been around for a lot of the reforms that have taken place, the biggest one being the First Step Act. Isn't that right?
Yeah, it's amazing, actually. I guess when we initially think about the First Step Act, we think about, okay, well, look, they supposed to increase opportunities for people to earn good time based on participating in programs.
Earn time.
Yeah, earn time, definitely. Okay, yeah. To me, it's the same thing, but yeah, I mean, obviously, there's a distinction between this language here. Earn time.
Isn't it a big distinction, Josh? Because good time, you're truly getting time off of your sentence, right? But earn time, isn't my understanding, and correct me if I'm wrong, it's going into a bank that qualifies you to go to home confinement or community confinement earlier. Am I wrong?
No, you're correct. I mean, again, we get into this nomenclature issue. It's just about, these distinctions between one or the other. I mean, to me, it's like you actually have to earn your good time too. I mean, if you get in trouble, if you don't participate in programs, participate in FRP, I mean, there can be a bunch of different things that actually affect that too. But yes, in this respect, it isn't time that's actually coming off the tail end of your sentence. It's time that you could have otherwise been forced to spend in actual prison custody is being then either spent on home detention or in a community corrections facility.
When I was in prison and when I do a lot of writing, I talk about good time. I think it's a bad name, good time, truthfully. You just described it a little differently from the way I understand it. I understand good time. The real name should be not getting bad time, because good time's really automatic as long as you don't get in trouble for the most part. Yes, you have to get a GED if you don't have that. Yes, you have to participate in FRP, but those are kind of like normal table stakes. But I don't really have to do anything extraordinary to get good time. I just don't have to get a disciplinary infraction. I'm going to get it. Is that right?
No, because I mean, as you and I know, I mean, I may be a little bit more pragmatic about it, but there really aren't a whole lot of opportunities in the Bureau of Prisons to begin with. So, it's about warehousing. So at the end of the day, it's, as so long as I don't get in trouble, I don't get caught with wine, or I don't get caught with the cell phone, I don't have to do anything extraordinary really to get this, good time taken off my sentence. So yes, of course, it's better to bad conduct.
Call it the avoidance of bad time. So as long as you kind of go by the rules, you're going to get the good time. Earn time, on the other hand, it does require you to participate in a program that the Bureau of Prisons is authorized. And then you get this earned time that goes into like a bank account that you cash in at the end of your sentence. Is that the way you understand it?
Yeah, that's definitely the way that I understand it. I mean, as we know, the parameters are still kind of loosely defined here. We're still waiting for a lot of the implementation to take place. So yes, as we understand it at this point, it's still developing. But yeah, that's the gist of it.
But there is also a really important distinction with the First Step Act, and that's what I want to spend the rest of our time on today. And that's this concept of compassionate release. That is a unique provision of the First Step Act that did not exist when you were serving time or when I was serving time. Could you help our audience understand this concept of compassionate release in accordance with the First Step Act?
Well, it's kind of ironic because the changes that are now really sort of opening the door wide open for people to take advantage, and based on a showing of extraordinary and compelling reasons to get out. Initially, I guess when Congress was first thinking whether they were going to pass the First Step Act, it was supposed to be about expanding compassionate release for people that are dealing with terminal illness or terminal illness of a family member, that they were like the primary caregiver to their wife or to their mother or to their father. And, really it used to take something extraordinary. But now, as the way that the courts are sort of interpreting it, it's it's become way larger in terms of reforms and the stakes than these earned time provisions and the other changes that were, I guess, initially anticipated. The sense of compassionate release is sort of, swung the door wide open based on the fact that you could, upon a showing of, it can't just be solely rehabilitation, but rehabilitation plus something else. Even if it is obviously now the first thing that we, sort of comes to mind is COVID. We're in the middle of a pandemic. It still hasn't sort of cleared up, but people with underlying medical conditions that the CDC has recognized as putting them at risk for severe risk of complications or actually dying as a result of contracting COVID. Courts have, given a lot of people compassionate release based on that. Well, go ahead.
I want to interrupt you and just kind of crystallize, because that's an important distinction. And we're recording this video in March of 2021, but about a year ago, in 2020, at the start of the pandemic, there was something really extraordinary that happened, and that was the Attorney General of the United States, Bill Barr, issued a series of memorandums. Could you just describe a little bit about what those memorandums said in relation to the CARES Act?
Well, there were several of them. And I mean, obviously, as we've seen this thing progress, initially at the outset, it was that based on the CARES Act that Congress had sort of enacted, that out of concern for people with underlying medical conditions that placed them, at significant risk in the event that they would have contracted COVID. The presumption, aside from what we've seen the 25 or 30 years before that, where basically nobody was getting out unless you finished your sentence, that now the concern was that they prioritize release for people with underlying medical conditions for the first time, and I don't know how long.
Yeah, that was a big deal because the nation was the whole world was going through this pandemic, but it's the first time, certainly in the 26 years or since I went into the prison system in 1987, since you went into the prison system, where we had the Attorney General of the United States, the chief law enforcement officer, directing the director of the Bureau of Prisons, you have the authority under the CARES Act to release people under compassionate release. That's never happened before, correct?
No, it was truly unprecedented. Although obviously we still hope that many more would have gotten out aside from the ones that did, there were a large number of people that got out, and I was just amazed.
And you played a role in helping some of those people getting out. It didn't mean that the CARES Act did not help a person say, here's a get out of jail free card. You still had to go through this process. And that's an important part for anybody to understand. There's always a process. The Bureau of Prisons is a magnificent bureaucracy in the sense that it's the Department of Motor Vehicles times 100. And there are policies and procedures for everything and a process for everything. What was the process to launch an initiative for a compassionate release under the CARES Act starting about a year ago with using the First Step Act? I mean, there was an administrative remedy and an issue to go through the courts. Could you help the audience understand those two pathways?
Well, I'll start basically with the CARES Act, since that's sort of like goes in line with what we're talking about. The CARES Act itself wasn't really enforceable, in terms of like going into court. It just, the Attorney General issued these memos based on the statute that had been enacted by Congress, and it sort of encouraged the Bureau of Prisons to give people, home detention rather, for issues that might arise if they contracted COVID because they had certain underlying medical conditions. Obviously, we would hope that they would have made these decisions by themselves, but a lot of times inmates would more or less have to make requests. Those requests would either be, granted or denied. In most cases, they were denied. And as a result of that, you would have to have went through, the administrative remedy process, BP8, BP9, BP10, BP11, sometimes even, try to lobby with the residential reentry manager that sort of handles, the home confinement assignments in different districts and stuff like that. It was a long, complicated process that a lot of us, and I mean, even, legal practitioners themselves, because it was unprecedented, it was the first time it's happened, figuring it out along the way. I mean, a lot of times there wasn't, a one solution, that went into approaching these cases. Oftentimes, it took doing 2 or 3 of these things before finally you got the right person's attention. And then finally, you get a lot of people ended up getting out. We've had clients, obviously, that we wish they would have gotten out that didn't, and probably should have, but the call isn't ours. It's in the Bureau of Prisons.
Well, it's in 2 places. And I was looking for more along the lines of, aren't there 2 processes? One process is administrative remedy, where you have to first ask the Bureau of Prisons to consider you for compassionate release. And if the Bureau of Prisons doesn't respond, the person can then ask a district court judge. Am I inaccurate on that?
With respect to the CARES Act, the CARES Act isn't enforceable in the court. Now, compassionate release, however, under the First Step Act, the changes that were made to Title 18 United States Code, Section 3582C2, those, I think, in terms of exactly what you're talking about, that's kind of a distinction. That's actually a reduction in the sentence versus the Attorney General having the authority to tell the Bureau of Prisons to basically place you on home detention. That was not a reduction in your sentence, but the fact that they're just placing you on home detention to serve out the remainder of your sentence that you would have otherwise served in prison.
But if it were not for the First Step Act, a person would not have had the opportunity to go back in this way, or at least the doors wouldn't have been so wide open to try this. Is that correct?
Yeah, the First Step Act, and that was I was going to roll into the second part of my explanation, which is you can also, the director of the Bureau of Prisons also has the authority to motion the court to reduce an individual's sentence to be compassionate released. Sometimes they order as a condition of that, a certain period of time be spent on home detention, but it's actually a reduction in the sentence. So they can reduce they now have the authority and the discretion to reduce a sentence based on, a motion for the director of the Bureau of Prisons, or if the Bureau of Prisons doesn't, for whatever reason, opt to do that, once a defendant has asked the warden and the warden's given 30 days, then based on, even if they don't respond or they say no, that they aren't going to make a motion, the defendant then can actually, for the first time in 25, 30 years, proceed into court and ask the judge for a reduction in sentence. That's
the big change, the big reform that really every person who was either in the system or going into the system should really understand this didn't exist when you were serving time or when I was serving time. Isn't that accurate?
Yeah, it's unprecedented. I mean, it was almost impossible to get it done before. I mean, and now basically once you follow those procedures, you have an opportunity for the judge to either say yes, based on whatever, the extraordinary.
You give them jurisdiction back.
Exactly. Exactly.
And there were two prongs, and I heard you mention them in the initial part of your answer, and that is extraordinary and compelling reasons. Are those the two? Is that the standard that a district court judge is going to use to assess whether it makes sense to grant resentence the person to a lower term?
Yeah, basically extraordinary and compelling reasons, but I mean, they also have to consider Title 18 United States Code 3553A, the sentencing factors. There's A1 through A6 that they have to consider, and just basically whether a reduction in the sentence is warranted under those circumstances. And in addition thereto, there's policy statements that have been issued by the United States Sentencing Commission that says that the judge also has to determine that the particular individual applying for this won't be a danger to the community upon being released. So that basically that they're not a threat to the public, that reducing their sentence wouldn't put the public at risk if this individual were released.
So it's really important that every person understands the only person who can file, there's only two ways to pursue this path. One of them is to hire a lawyer who is authorized to practice and submit motions on behalf of a defendant. The second is for the defendant to do the work himself. Isn't that right?
Yeah, I mean, unfortunately, you would like to think, especially for people that, have these underlying medical conditions, that with the pandemic and with the death toll being as high as it is, unfortunately, I mean, we've surpassed 500,000. It's a shame. You would think that they would put people in a position to be represented by counsel, but everybody just hasn't had that opportunity. And as a result, I think the death toll in the Bureau of Prisons yesterday was at 224 inmates and 4 staff members, which is terrible.
Right. My question, though, is that if I'm in prison and I want to file this motion, my only option is either to hire an attorney or a public defender to represent me, okay, to present that motion to a district court.
Yeah.
Or
yes.
I've got to do it pro se. Isn't that right?
Yes, exactly right.
I can't hire somebody with a vast amount of experience like you and say, Josh, I want you to file this motion in court. You can't do that, correct?
Unfortunately, no. I mean, the onus is on the individual here. And that's pretty much the two options that we have. Unfortunately, that's what we're looking at. But
that's okay, because although you can't file a motion, you do have the benefit and the wisdom of 17 years, having been in prison 17 years and having done a lot of pro se work, not only for yourself. Well, actually, let's talk about that. When a person is in prison, doing multiple decades in prison or multiple years in prison, and that person becomes skilled as a jailhouse lawyer, meaning he's not authorized by the bar, but he becomes skilled. Is that person authorized to help other people who are serving time with him prepare motions to submit it to the court?
In that context, yes. I mean, that was pretty, since they, once you have the trial, the sentencing, the direct appeal, these are the only parts of the, representation in the legal process that the Constitution actually entitles you to have an attorney and have representation. Unfortunately, you have to do those other things yourself.
Right. But the Supreme Court, my understanding, is authorized. If you are in prison and you are more knowledgeable than me about the law, I could ask you to help me and you could help me write my brief, and that would be okay. Is that accurate?
Yes.
And did you serve in that capacity while you were serving time in prison? Did you help hundreds of people prepare briefs that they could file in court pro se?
Yeah, that was my thing in prison. I mean, from coming in there from day one, I mean, I spent 6 to 10 hours in the law library almost every day for 15, 16 years.
So you learned, and I know that our friend Sean Hopwood, who's now a lawyer and a law professor, he told me you were as good as he was. That's exactly what he told me while you were in there. and, and he said he wouldn't say that about anybody else but Josh Boyer.
Well, I mean, I definitely compliments. I mean, I'm definitely not going to turn them down, but you learn a lot. I spent a whole bunch of time. I mean, I've talked to, lawyers fresh out of law school all the time. And, they told me, they said, man, it's probably going to take me 5 or 6 years to even catch up with the stuff that you probably already know and don't even have to look in a book for. So
you've got a lot of depth and breadth of experience.
Yeah. It's, hey, look, what are my odds? What are the chances? Do you think this is going to get granted? And at the end of the day,
it's like asking how long is a piece of string? I mean, I don't know, right? Yeah. You just don't know. But I know one thing: if you don't file, you have a 0 chance.
Definitely.
You have a 0 chance.
With compassionate release, they're never just going to say, oh, well, hey, look, I feel sorry for this guy. He's got a medical condition, or he's been a model prisoner. They're never going to do that on their own.
And the judge is not even going to know. The judge doesn't even have jurisdiction unless the person files the motion. So the judge can't even do it. But once you file the motion, now at least you're in the game. Maybe, maybe not. Nobody can change the past and nobody can predict the future. But what a person can do is they can say, how do I make the most compelling case to show that it's extraordinary and it's compelling? Now, words and sentences and paragraphs alone are not going to do it. The person should have done something to differentiate himself or something to demonstrate why he's worthy. That's an area that experience becomes very valuable. But it's always important for people to recognize there's no promise of what's going to happen. The only thing we can promise you is if you don't file, nothing will happen.
Definitely. And when it comes to most members, and I'm not saying all members because we do have quite a few good United States District Court judges and elsewhere, but when it comes to most United States District Court judges, and that's the first level here, if exactly the judge that sentenced you is who's going to consider it, they're going to take some convincing, especially if they decided to impose that sentence and the Sentencing Commission and everybody else has created these sentencing ranges that based on the specific characteristics of the offense that everybody felt at the time that it was imposed that the sentence was warranted. It's going to take some convincing. It isn't something to say, okay, well, hey, look, judge, feel sorry for me. I want to get back to my family.
Well, that's similar to saying the clemency was the same thing. It took convincing. It's the same thing that happened with Adam Clausen, who was serving 200 plus years. Something happened. He did something that your team worked together and as a result got him out of prison. Isn't that right?
Well, Adam did most of the work there, Michael, but yes, without having somebody, know how to articulate that and put it together. Adam Clausen being the model inmate that he was at the time and, just the extraordinary individual that he developed into without having somebody to tell that story. Nobody would have done it on their own. The Bureau of Prisons, they would not have just said, oh, hey, look, Adam, you've been, a model inmate. You've had exemplary conduct. You've created this entire, curriculum for people to get inside and to change and to better themselves. We just think that you should get out of prison now. Let's just file a motion for you. That doesn't happen.
Yeah, it really takes extraordinary persuasiveness and packaging and advocacy. It's really about personal advocacy. You did mention that Adam did most of the work. He did the work of preparing himself well while he served his time, but your team did a lot of work to position it in such a manner to make an effective outcome. And I know that you, over the course of the pandemic, as I recall, you've done about, how many of these? About 40?
Probably. Yeah. We were sitting there, you and I were sitting there talking the other night. I was trying to sort of like put it together in my head, but yeah, It's been a bunch in a
So
short
let's
period.
say it was 40, and of those 40, you said that how many got the relief they wanted?
The low margin, like 6 or 7.
So let's just start right there. Let's call it 6. So out of 40, 15% got the relief they wanted, roughly. Is that right?
Yeah. And not only was it that percentage, it was some of the cases that I thought had a way better shot than others. Some of the people that I thought that might have had slimmer chances ended up winning, and some of the people that I thought were going to be winners ended up losing. It's about the discretion of the judge and telling the story.
Exactly. So that's 15%. That means 85% did not get it.
Yeah.
Correct? And so it's important for anybody that's pursuing this path to understand that. It's also important to understand that in my opinion, it's important for somebody to understand that if the person didn't submit, you don't know. Those 6 people that got out of prison, they are home with their families now. That would not have been the case if they didn't take the shot. Right?
Unfortunately, yeah.
They'd be sitting in prison
that's the reality
right
of the
now.
situation that we're in. That's exactly what it is.
They'd be sitting in prison right now. So I always like to give, the good and the bad. And the good is that, number one, First Step Act did not exist when you and I served time. You did a lot of extraordinary things in prison, and you got clemency. But some people may say, I did something good while I was in prison, but nothing happened. I served every day of my sentence, okay? Because this didn't exist. Second, even though it exists, it doesn't necessarily mean that justice is going to prevail. It doesn't necessarily mean a person is going to get out of prison. All it means is you've got a shot. If you want to take the shot, you may be like one of those 6 out of 40 that got relief. If you don't take the shot, you don't ever find out. Yeah. So it's really something that I want people to be aware of. Josh is an expert in understanding what worked while he was in prison, and he doesn't BS anybody. That's why I respect him. He'll say this, you can only try. There's no guarantee of an outcome. But if you don't try, the only guarantee is you're going to serve your entire sentence. During the 16 years that you served, Josh, how many people requested your help in filing motions that they wanted to file in court?
Several hundred.
Well, how many of those people did you help?
I helped all of them. They may not have ultimately got what they wanted, but in the end of the day, I mean, I've had several people that have gotten resentenced, several people that have helped get their guilty pleas vacated, gotten reversals on district court judgments, a bunch.
But if those people didn't file motions in court, how many of them would have gotten relief?
None, unless the person, initiates some type of appeal or file some type of petition. The legal system, unfortunately, isn't in the business of, trying to sift through each case that they've presided over to determine whether a mistake has been made.
So it's the same thing with compassionate release. If a person wanted to file a motion under compassionate release, who is authorized to file that motion on their behalf?
Only a lawyer or the individual themselves.
So if that person doesn't want to hire a lawyer, or maybe doesn't have tens of thousands of dollars to hire a lawyer, and the person doesn't know how to file the motion themselves, is it okay if they ask guidance? For example, like, can they ask how you would have done it while you were doing 16 years in prison?
Yes, they could ask me what I have done, and I'll tell them what I've done.
Yeah, because I mean, you did things and you got clemency, right? So it would be worthwhile to learn what did you do. So you're allowed to tell them what you would have done.
Definitely.
And if they listen to you and learn from you, then that person can make his own decision on whether he wants to do the same kind of thing that you would have done, right?
Definitely.
So that way the person's making his own decisions. So ultimately, though, the person has to file his own papers and be responsible for whatever motion he submits. Isn't that right?
Yes. If they don't want to hire a lawyer, essentially they have to do the work themselves, and they're going to have to be, the final arbiter, in this entire process.
So, Josh, anybody that would have the benefit of listening and learning from you, somebody who's been in prison for 16 years and been very active in litigation, that is a real plus. And we're super grateful to you for making yourself available to people who want to hear, hey, am I doing this right? You know, I know you can't give an opinion. You can only tell them what you would have done.
Definitely. Yeah. It's in this situation, it's almost 2 decades worth of experience.
Yeah, it's awesome experience, and it's experience that has resulted in many people going home, and they're home right now. Not everybody; it's only 15% of the people that you revealed that you've worked with. But that's super exciting, and it must be very fulfilling to know that you had a role in helping people return to their families when otherwise they'd still be sitting in prison, standing up for count.
Definitely, it is. It has been, Michael.
Well, Josh, on behalf of our whole team here at Prison Professors, we want to thank you for all the work that you do and using the wisdom that you gained while going through prison to help other people get better outcomes. So thank you.
Definitely.
Okay. So now we got it. And